Hello everyone, welcome back to Legally Dephine and a special welcome if you are new here to our channel. This is Legally Dephine where we simplify the law. In this video, we are starting on a new module which is Family Law in Zimbabwe, and we will kickstart it with the types of marriages in Zimbabwe. And as usual, make sure to subscribe, like and share. Let's get into it. The types of marriages that we are going to cover are civil, customary, unregistered customary, and qualified marriages. We will also discuss on civil partnerships. However, before we move on to the types, let's quickly define a key term that we will use over and over throughout this video: solemnize. To solemnize a marriage simply means to legally formalize it through a ceremony or process recognized by the law. It's when your marriage becomes official and legally binding, not just a private agreement. You will hear me say solemnized under Marriages Act Chapter 5.17 more often. So make sure you remember the definition because it's very, very important. Before 2022, Zimbabwe had two major marriage laws. There was the Marriages Act for civil marriages and the Customary Marriages Act for customary marriages. However, things changed and Zimbabwe now has one combined law for all marriages, which is the Marriages Act Chapter 5.17. This law came into operation in September 2022 and it repealed the previous marriage laws. The Act now recognizes different types of marriages and relationships under one legal framework. In simpler terms, this is what we are saying. Before 2022, we have the Marriages Act and the Customary Marriages Act standing separately. The Marriages Act governing civil marriages and the Customary Marriages Act governing customary marriages. But after 2022, these two laws have been combined under one act, and now we find them in one act or document which is called an Act of Parliament. In terms of Section 5, subsection 5 of the Marriages Act, all marriages registered under the Act are equal. That means a customary marriage is not considered inferior or less important to a civil marriage. The law also says that no person under the age of 18 years can legally marry. That protection came after constitutional changes and court rulings against child marriages in Zimbabwe. Now, let's look at the actual types of marriages recognized under the new Marriages Act Chapter 5.17. Civil marriages fall under Part 5 of the Marriages Act Chapter 5.17. A civil marriage is what many people refer to as a court marriage or a marriage under general law. It is strictly monogamous, which means one husband, one wife, and no second spouse is allowed while that marriage still exists. This is in terms of Section 5, subsection 1 of the Marriages Act, and it provides as follows. A civil marriage is monogamous. That is to say, it is the lawful union of two persons to the exclusion of all others, and no person may contract another marriage during the subsistence of a marriage under the general law. Therefore, if someone who is already in a civil marriage marries another person, it can amount to the criminal offense of bigamy under the Criminal Law Codification and Reform Act. Under the Marriages Act, civil marriages are usually solemnized by a magistrate or a registered marriage officer who is usually a minister of religion. Here are the requirements for a civil marriage. Both parties must consent freely. Both parties must be at least 18 years old. They must not be closely related within prohibited degrees of relationship, and neither party should already be in another civil marriage. The paying of a bride price, otherwise known as rowora or lobola, is not a legal requirement for a civil marriage. However, some couples still choose to pay the bride price or rowora and then they proceed to their civil marriage's wedding. But a civil marriage can still exist even without paying lobola or rowora. Once you're in a civil marriage, you cannot legally enter into another marriage during its subsistence. So a person married under civil law cannot enter into any other marriage legally as long as that marriage still exists. The customary marriage is contracted according to African customary law traditions. Unlike the civil marriage, customary law marriage is potentially polygamous. This is in terms of Section 5 subsection 2 of the Marriages Act, and it provides as follows. A customary law marriage may, subject to the customary law of the people concerned, be polygamous or potentially polygamous. That means a husband may marry more than one wife under customary law. However, whether or not that actually happens depends on the family dynamics and the culture concerned. But legally, customary law allows that possibility. One major feature of the customary law marriages is the paying of a bride price, otherwise known as rowora or lobola. In practice, the paying of the bride price usually forms an important part of the marriage process. Under the Marriages Act, customary marriages can be solemnized by a magistrate, a chief, or a registered minister of religion authorized to conduct customary marriages. The marriage can then be registered, and when registered, the couple is issued with a certificate. Registration is very important because it helps when dealing with inheritance disputes, property disputes, maintenance claims, pension benefits, and proving marital status. Take note that a person cannot be married under civil marriage and customary marriage at the same time. However, the law allows a registered customary marriage to be converted into a civil marriage if the husband has no other existing spouse. Once converted, the civil marriage takes precedence. This is in terms of Section 5, subsection 3 and 4 of the Marriages Act, and it provides as follows. Parties to a registered customary law marriage in which the husband has no other existing spouse in polygamy may convert their marriage to a civil marriage, and the appropriate marriage officer shall, upon being satisfied that there is no impediment to the conversion, solemnize the marriage in accordance with the general law, and the civil marriage shall supersede the previous customary law marriage in the marriage register. All marriages registered in terms of this act are equal. In simpler terms, this means that a man who is already married under customary law but he has one wife can convert that customary law marriage into a civil marriage. The unregistered customary law union happens where two people marry according to customary law but never formally register the marriage. This usually involves paying of lobola, family ceremonies, and traditional ceremonies, and then the couple moves on to live together as husband and wife. Under Section 17 of the Marriages Act, these unions must be registered within 3 months. However, failure to register does not automatically make the marriage invalid. The law still recognizes these unions for the purposes of maintenance, property, succession, and inheritance, as well as the status of the parties in the marriage. Section 17 provides as follows. A marriage contracted solely according to customary law and not solemnized in terms of this act must be registered by the parties to such marriage within 3 months of the date the union was entered into, or such later date as may be prescribed, and for that purpose, the parties to the union shall furnish to the registrar such information and in such form as may be prescribed, and any additional information which the registrar may reasonably require to enable the registrar to register the marriage. If the registrar is satisfied that such a marriage took place, he or she shall record the identity, particulars of the parties concerned, the date of the marriage, and brief details of the marriage consideration, if any, which was or is to be paid in respect of the marriage, whereupon he or she shall issue the parties with a certificate of registration of a customary law marriage. Failure to register a marriage contracted at customary law does not affect the validity of the marriage at customary law with respect to the status, guardianship, custody, and the rights of succession of the children of such marriage. The recognition of unregistered customary law unions is very important because for many years, unregistered customary law unions created serious legal problems, especially for women after the death of a spouse. That's why now the law gives more recognition and protection. However, there's still a challenge. If the marriage is not registered, proving that it existed can be challenging. Therefore, couples are encouraged to register customary marriages because if disputes arise later, evidence becomes very important. Another type of marriage recognized under the Marriages Act is the qualified civil marriage. This is less commonly discussed, but it is recognized under our Zimbabwean law. Section 44, subsection 1 of the Marriages Act provides for the definition of a qualified civil marriage. In this section, qualified civil marriage means a union between a man and a woman, not being a union registrable as a civil or customary law marriage under this Act, which is registered in terms of this section. Marriage officer for the purposes of this section means a person designated in terms of section 11 for the purpose of solemnizing marriages according to Islamic rites. A qualified civil marriage mainly applies to marriages solemnized according to Islamic rites. Unlike the ordinary civil marriage, a qualified civil marriage may be potentially polygamous, which means they may allow the man to marry more than one wife. This means the marriage recognizes religious practices associated with Islamic marriages. These marriages are solemnized by registered ministers of religion according to the Act. This is one of the major developments introduced by the new Marriages Act, Chapter 5.17. Section 41 of the Marriages Act provides for civil partnerships as follows. A relationship between a man and a woman who are both over the age of 18 years and have lived together without legally being married to each other and are not within the degrees of affinity or consanguinity as provided in Section 7, and having regard to all the circumstances of their relationship, have a relationship as a couple living together on a genuine domestic basis, shall be regarded as being in a civil partnership for the purposes of determining the rights and obligations of the parties on dissolution of the relationship, and for this purpose, Section 7 to 11 of the Matrimonial Causes Act, Chapter 5.13 shall, with necessary changes, apply on the dissolution of any such relationship. The circumstances referred to in paragraph D may include the duration of the relationship, the nature and extent of their common residence, whether a sexual relationship exists, the degree of financial dependence or interdependence, and any arrangements for financial support between them, the ownership, use, and acquisition of their property, the degree of mutual commitment to a shared life, the care and support of children, the reputation and public aspects of the relationship. No particular factor in relation to any circumstance may be regarded as necessary in determining whether or not the persons concerned have a civil partnership. Long paragraph, big words, but what exactly are we saying? We are saying that a civil partnership exists where a man and a woman are both above 18 years old. They live together without being legally married, and they are not related. Take note that a civil partnership is not a marriage. It is not the same as being legally married. However, the law simply recognizes civil partnerships for the purposes of dealing with rights and obligations when the relationship ends. For example, property disputes, contributions made during the relationship, financial claims, and issues to do with children. Therefore, simply living together does not automatically create a marriage, but the law may recognize certain rights arising from the relationship. This was partly introduced to protect vulnerable partners who may have spent years on years contributing financially or domestically to a relationship without being formally married or without a formal marriage. Here's a quick recap to those who are still watching and have made it to this point of the video. Number 1, child marriages are illegal. You cannot marry anyone who is below the age of 18 years. Number 2, customary marriages and civil marriages are both legally recognized. One is not superior to the other. Number 3, an unregistered customary law union may still be legally recognized, but registration makes legal proof much easier. Number 4, living together does not automatically mean you are legally married, but the law may still recognize certain rights through civil partnerships. And number 5, before getting married, it is very important to understand the legal consequences of the type of marriage you choose, because different marriages can affect inheritance, property rights, succession, maintenance, and even the legality of future marriages. And just like that, another Legally Dephine video done and dusted. But as usual, we always need your support. So make sure to subscribe, leave a like, and share the video with all your friends and anyone who you know that they are in dire need to learn the law. Thank you so much for watching, and until we meet again.